Foreign investors often encounter legal barriers in Vietnam, especially foreign ownership caps in restricted sectors. To bypass these limits, some resort to nominee structures, where a local Vietnamese individual holds shares on behalf of the foreign investor. While this may seem like a practical workaround, it carries significant legal, financial, and operational risks. In this video, we explain how nominee structures work in Vietnam, the risks involved, and safer legal alternatives. 1. What is a nominee structure? A nominee structure is when a local Vietnamese individual or company legally holds shares in a business, but in reality, acts on behalf of a foreign investor. The nominee is the shareholder on record, but private contracts, such as loan agreements, voting proxies, or trust deeds, give control and benefits to the foreign party. These arrangements are often informal, undocumented, or written in a way that avoids detection. 2. Why nominee structures are used. Investors use nominee structures when the target business falls into a sector with foreign ownership restrictions or where M&A approval is difficult to obtain. By having a local person hold the shares, the business appears locally owned, allowing it to maintain licenses or avoid regulatory scrutiny. Common sectors include advertising, education, media, and retail distribution. 3. Legal status of nominee arrangements in Vietnam. Vietnamese law does not explicitly ban nominee structures. However, contracts that conceal true ownership, evade regulations, or mislead authorities may be declared invalid under the Civil Code and investment law. Courts have ruled against foreign investors in cases involving nominee structures, especially when disputes arise. In essence, these contracts are legally fragile and offer little protection. 4. Risks to the foreign investor. The main risk is loss of control. If the nominee refuses to transfer the shares, mismanages the company, or absconds, the foreign investor may have no enforceable claim. Since the nominee is the legal owner, they can vote, sell, or pledge the shares. Vietnamese courts may reject claims based on nominee contracts, especially if the purpose was to bypass legal limits. This exposes the investor to irrecoverable loss. 5. Risks to the nominee. Nominees also face legal exposure. They may be held liable for tax obligations, corporate violations, or even criminal conduct linked to the business. If the foreign investor defaults or disappears, the nominee remains responsible for any outstanding issues. Many nominees do not fully understand these liabilities, creating further instability for the business. 6. Regulatory risks. If the authorities discover that a foreigner is the true owner behind a local nominee, they may revoke licenses, impose penalties, or block future approvals. The business may be forced to restructure or shut down. In high-risk sectors, regulators have increased scrutiny of ownership structures, especially when foreign capital is involved. This risk increases during tax audits, licensing renewals, or corporate disputes. 7. Reputation and operational risks. Nominee arrangements can damage business credibility with banks, partners, and customers. Financing is harder to secure when the real decision-makers are hidden. Internal governance may suffer from confusion over authority. Disputes between nominee and investor can freeze operations. Exit options are limited because formal investors and acquirers often refuse to buy into nominee-based businesses. 8. Safer alternatives to nominee structures. Instead of using nominees, investors can explore legally compliant alternatives. These include forming joint ventures with local partners, where ownership is real and structured through proper agreements. Another option is restructuring the business model to fall within sectors that allow full or majority foreign ownership. In some cases, using convertible loans, management contracts, or licensing models can offer control without breaching ownership rules. 9. Use of reserved matters and SHA rights. If foreign ownership must remain below 50%, control can still be preserved using strong shareholder agreements. These agreements can include reserved matters, board representation, profit-sharing mechanisms, and exit rights. These tools provide influence and protection without violating foreign ownership caps. Legal drafting must be precise and aligned with Vietnamese law to be enforceable. At LTS Law, we help clients avoid the trap of nominee structures by designing legal, enforceable solutions that achieve the same commercial objectives. We advise on joint venture structuring, control mechanisms, licensing models, and sector-specific strategies. Our goal is to give clients control with legal certainty, not just risk avoidance, but strategic protection. Nominee structures may offer short-term access, but long-term stability comes from legal compliance. Don't compromise your investment with hidden risks. Contact LTS Law or visit lts.com.vn to explore safer, smarter alternatives tailored to your goals. When the law sets limits, we build solutions.